Consideration of bills on general file. Madam Majority Floor Leader.
Mr. Vice President, I move that the Senate resolve itself into committee.
This is, here we go. Madam Majority Leader.
Mr. Vice President, I move that the Senate resolve itself into committee of the whole.
You have heard the motion. All those in favor say aye. Those opposed? Carried. Senator Case.
The Committee of the Whole will come to order. The first Senate file for our consideration is Senate File 32. The reading clerk will please read the file.
Senate File 32, Unpaved Roads Speed Limits Amendments, an act relating to speed limits, sponsored by the Transportation Committee. It was referred to Committee Number 8, which returned a committee recommendation that it do pass. Ayes, Senators Anderson, Cooper, Kolb, and Pappas. No, Senator Brennan. Senator Pappas, Chairman.
You've heard the reading. You've heard the reading of the file. What is your pleasure, Senator Pappas? Are we going to speed through this bill?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, that it do so with a favorable recommendation on Senate File 32, Unpaved Road Speed Limits Amendments. And for an explanation of this bill, I ask you to call on Senator Kolb.
Senator Kolb. Whoa, you got a backup plan? Back to you, Senator Pappas.
Yes. Mr. Chairman, let me grab my bill here, and I will keep it in my court. Okay, so Senate File 32, Unpaved Road Speed Limit Amendments, was a product of your Joint Interim Transportation, Highways, and Military Affairs Committee. The premise behind this bill is to allow local control to the counties to set speed limits up to 55 miles on unpaved roads. That's dirt roads and gravel roads, without a speed study. Currently, a speed study is required for them to change the speed limit, and this little bill will allow the counties to set their speed limits on any unimproved road, gravel or dirt roads, up to 55 miles an hour without that speed study. So it's a fairly simple bill. I'll stand for questions.
Okay, questions for Chairman Pappas? Any questions? Any questions for the chairman? Senator Barlow.
Thank you, Mr. Chairman. Mr. Chairman, just to clarify, I think it was mentioned in the testimony that it was about specific to county government. When I read the bill, it actually talks about local authority. So I would just inquire whether that could be cities, towns, other jurisdictions would have that same authority. I understand they may not have miles of roads, but would this also apply in their jurisdictions as well? Thank you, Mr. Chairman.
Thank you, Senator Barlow. And Senator Rothfuss.
Thank you, Mr. Chairman. I understand the impetus for trying to create some simplicity to this, but I guess the question is, was there a discussion about what the implications are from a liability standpoint if a community fails to do any type of study to set up what is a safe speed zone and then adopts a speed zone of, say, 55 miles per hour? We see that that's the limitation on the F paragraph. But it turns out that it's really only 35 miles per hour that it's effectively safe. So you end up having somebody that can't take the corner, does a rollover, and they point back and they say, well, there's a 55 mile per hour sign. How is the liability associated with that handled? It seems like that's the whole purpose behind the speed study in the first place, is the idea that you've got some sort of rational justification behind the speed limit that is defensible if there were some legal challenge. And by taking that away, are we putting our communities at risk of lawsuit?
Senator Hicks, and then afterwards, we've been piling on enough, we'll go back to Senator Pappas. Go ahead, Senator Hicks.
Mr. Chairman, to address my colleague from Campbell County's first inquiry associated from local authorities to counties, for somebody that lives in a municipality that has gravel and dirt roads in them, it just only made sense to include those municipalities. Don't have to go out and do a study to change the speed limit within the city limits. So I think that's probably a better accurate reflection of the need for this. We don't have to do a transportation study. If it meets these standards of a gravel or unimproved road, certainly there is a number of municipalities around the state of Wyoming. In fact, I would say probably 90% of the ones that I represent that have some city roads that are either gravel or dirt. I think on the issue of liability, I think those entities are still liable, regardless of whether they set the speed limit or not. Without the studies, I can tell you this was an issue in Carbon County, because it takes these studies can literally take years to complete, and they can be tremendously expensive to do this. And so we had a situation in Carbon County where we have a historical thing called Aspen Alley. Many of you have seen pictures of it anywhere you go, all over the place. And to preserve that historical nature, they kept that road very narrow. Now it runs into a county road that's normal county width and road. And the issue came up is just to change that 1/4 mile speed limit, the county, to say this is not suitable for all the other road that's coming in, all this upgraded, improved road. It was looking like this was gonna, literally could cost tens of thousands of dollars in a year and a half to go do a transportation study, other than going from a 55 minimum just down to a 25-mile speed limit through that kind of a historical zone. So this really kind of tries to address some of that, but again, I think the reason local authority is in there is because of some of our municipalities. Anyway, hope that helps provide some clarification on the bill.
I thank the great senator from, that sits directly in front of me. It is open to all local communities, local, county. We did not have a member of the group of municipalities testify, but we did have someone from the county commissioners testified, and that the question of liability did come up. In fact, I believe I asked it, and there was not an issue. They're fully aware that they're going to be liable. The liability, I think it would be very difficult to try to put parameters around the liability, but if they're willing to change the speed limit, they're willing to take on the liability. Thank you, Mr. Chairman.
I promise you I'm not turning myself off. Anybody else speak on this bill? Anybody else? Senator Brennan.
Thank you, Mr. Chair. It was a privilege to hear this bill. I share some of the concerns that were raised by the good senator across the room, that without these studies, I think that they're needed for safety reasons, and I'm not sure that we've really settled on all of that or have that all worked out. And so I just urge us with caution on this bill. I think that there might be some unintended consequences and implications that haven't been discussed.
Thank you, Senator. See, we'll go to Senator Cope. We're going to take you first. Your name was mentioned earlier, sir. Senator Cope.
Thank you, Mr. Chairman. I was trying to recover my Trona that I still haven't recovered, because I should have been the one presenting this. So just to say, this is a local control bill, and I probably going to repeat myself, so excuse me if this was said before. This is a may bill. You may do it if you wish. You may not if you don't wish. Fact is, the counties have the liability no matter what. And as an ex-county commissioner for 8 years, I can assure you that Sweetwater County is in excess of 30,000 miles of two-track roads. And the road conditions change moment to moment, day to day, rainstorm to rainstorm. So if you post a 55-mile-an-hour sign up, I'm afraid people that drive on the roads realize that you have to, have some sort of awareness of what's going on with the conditions around you, because even the best dirt road that say you've got calcium chloride on it to keep dust control down, what packs it pretty good, even those roads go south under certain conditions. So it's always been kind of frankly, kind of a safe and sane situation out in the county. And we had a varying situation with some areas within the state of Wyoming that had situations where they had subdivisions where they were trying to control the speed to subdivision and require them to get a speed study. And they wanted to lower the speed limit. Some places wanted to raise the speed limit. So who else would make this decision better than the people that were elected in the county as county commissioners? When they take the liability, they know their roads, they have road engineers, some of the time, we do in Sweetwater. But they understand what they were elected to do. And this merely gives them a tool that doesn't encumber the cost of a speed study when they choose not to have one. So this is an optional thing. If you want one, you get one. If you don't want one, you don't have to have one. This gives latitude up to a certain point, and if you go above 55, you have to get a speed study. So it gives total flexibility back to the counties, and the board, and the Wyoming County Commission Association is supporting this, just to be clear. These roads are in the county, not in the city, just to be clear. So these are county issues, not city issues. If we're going to talk about, what might be the difference, well, they are totally different. So I'm in favor of this bill, and I'll look forward to listening to more debate, Mr. Chairman.
Thank you, Senator. Senator Ide.
Thank you, Mr. Chairman. Yeah, the good senator from Laramie County, I tend to agree with a few of her comments. There's maybe some unintended consequences here. Just thinking about it, speed limits are the maximum, and unless there's a minimum, you can slow down if you want to. And just the fact that, it's the localities unilaterally can make that decision. I don't know, maybe some of the ranchers and stuff want to weigh in out there if there's only two of them out in the countryside. Thank you, Mr. Chairman.
Thank you, Senator. Anybody else? Anybody else wish to address this bill? Are you ready for the question? The question is on Senator Pappas's motion that when the committee of the whole rises to report, that it do so with a due pass recommendation on Senate File 32. All those in favor say aye. Aye. Any opposed? No.
No.
I believe the ayes have it. Senate File 32 has passed committee of the whole. Next file for our consideration is Senate File 43. The reading clerk will please read the file.
Senate File 43, Temporary Water Use Agreements Amendments, an act relating to water, sponsored by the Agriculture Committee. Was referred to Committee Number 5, which returned to committee recommendation that it do pass amended. Ayes, Senators Craigo, French, Ide, McEwen, and Pearson. Senator French, Chairman.
You heard the reading of the file. What is your pleasure, Senator French?
I move that when the committee of the whole rises to report, it do so with recommendation that Senate File 43 do pass. And for an explanation of this bill, I call on Senator Craigo.
Thank you, Senator French. There was a standing committee amendment. We're going to do that a little bit later, you think?
Yes.
We can catch it later. Thank you. Okay. Let me get Senator Craigo's microphone. Go ahead, Senator Craigo.
Thank you, Mr. Chairman. So I bring to you Senate File 43, Temporary Water Use Agreements Amendments. And so what this bill is intending to do is change the amount of time for which a temporary water use can be applied for. Currently under statute, it's 2 years, and those 2 years can be renewed essentially for as long as the person wants to renew them successively. To every 2 years they can come in. Problem is creates a lot of work for our good state engineer's office, and so this bill changes that. On page 2, you can see it changes it from 2 to 5 years. The other thing it does is clarify and really just simplify the purposes for which temporary water uses can be had, which is pretty much everything except in-stream flow. And there's this big, long list on page 2, and that dates back a long time from when it was originally brought into statute. It had to do with, typically it had to do with highway projects, and that's what they were usually using it for. But there's this clause in there on line 7 that says, or other temporary purposes. So that's been used by the state engineer's office historically for many, many years to use these processes for essentially whatever purpose there may be. And so we're just clarifying that that's the historical purpose. We're taking out all this language and just making it clear that anything except in-stream flows can qualify for a temporary water use. If you move to page 3 on the bill, what we did there is put a limit on how long you can actually do the temporary water use agreements from, you can do 2 successive 5-year periods. And then there's on lines 6, 7, and 8, it limits it to those two timeframes, and it cannot extend past 10 years without transferring it to a different purpose or a different place. And at this time, I would ask that we read in the amendment, Mr. Chairman.
Reading clerk will read the amendment.
Senate File 43, Standing Committee Amendment number 1, page 1, line 3, after.
Senator Craigo.
Thank you, Mr. Chairman. And so I'm not going to move it quite yet. I will get to it in just a second, but it's important because as the rest of the bill from.
If you went ahead and moved it, it wouldn't matter. It'd be okay.
I'll move it then. Thank you, Mr.
All
Chairman.
right, because I might forget.
I'll
Thank you
move
very much.
Standing Committee Amendment number 1.
Thank you.
Senate File 43. Thank you, Mr. Chairman. So if we go on down through the rest of the bill, and this has to do with how these temporary use agreements are handled in priority. And so under current statute, both senior and junior water users have priority over a temporary water user pursuant to one of these agreements. And any temporary user would be shut off from their use if either a junior or a senior user, calls for that to happen. Under the current bill, we changed that as it originally came out of committee, out of the interim. We changed that, and so we changed who had what right and whether it would apply to junior or senior rights. In committee, pursuant to the amendment, we took all that language out and just reverted back to what's in the green books as of right now. And so that's what the amendment does, and I'm happy to answer any questions on either the bill or the amendment.
Okay. Questions for Senator Craigo? Questions on this bill? You ready for a motion on the amendment? Senator Scott.
Mr. Chairman, I hate to say it, but I'm having difficulty figuring out exactly what this amendment does, and frankly don't understand what we're doing, particularly with this amendment. Would like a little further explanation.
You bet. Thank you, Senator Scott. Appreciate that. Everybody else was thinking the same thing. They just weren't speaking up. So Senator Craigo, could you maybe go over that again?
Thank you, Mr. Chairman, of course. So the amendment at issue essentially keeps the law in Title 41 and it's 41.3.111. It reverts back to the current state of the law. We are not actually changing the law. That's what the amendment does. So the original bill went in and changed priority and who could make a call against the temporary user. What we're saying is we're going back to the original law as it has been in place for quite some time and taking that language out of the bill draft.
Senator Barlow.
Thank you, Mr. Chairman. And the reason it does that is because it strikes the language on page 3, lines 11 through the bottom of the page, and page 4, all of the new language. So that's why it's reverting back to the actual current state of the law. So actually, all that's being changed is that first paragraph. That's what will remain in the bill should this amendment be adopted. Thank you, Mr. Chairman.
Thank you. Looks like Senator Craigo agrees. Any further discussion on the amendment? Any further discussion? Senator Hicks.
Yeah, Mr. Chairman, just a question, because part of the rationale for including this when we worked this in the committee through the summertime was to try to make the language conforming to what we have with other statutes. And as I'll just point out, if you go to page 3 and you look at that and you go to line 15 through 16, that says that is senior in priority. And so that language is included, and that was try to make that consistent, uniform across all of our statutes, that we use the senior in priority, and then when we get back in here, the owner of a permanent water right and a junior water right. And so part of the discussion is to use that terminology. I don't know that this amendment affects it or not, but I mean, part of the rationale with just some of those changes was to make a conforming. Any discussion in the committee or with testimony from state agencies or the engineer as to whether that was something that was needed in there or not. But that was part of the discussion, is when we changed that language to get it from senior water right to priority water right to make sure that we had conforming. But just curious if there was any discussion in the committee on that.
Who would like to address the senator's question? Who would like to address? Senator Craigo.
Thank you, Mr. Chairman. Happy to do that. There was discussion about that, but what the discussion, essentially where we ended up was that it's not necessarily conforming because we're talking about a different right. So the temporary right is different than the historical senior or junior right, which most of those end up being agriculture. And so personally, my concern and what I expressed to the committee and what others talked about and I think agreed, which is why we agreed on the amendment, is we don't want non-agricultural uses trumping those agricultural uses for the purpose of temporary water agreements, temporary water use agreements. And so that's why we ended up taking that language out. There is a provision, if you look, the second part of that on page 4, it divided out the process for junior versus senior. And so how could a junior user to the temporary user's rights make a call essentially and ask for the water to be shut off? And it wasn't very clear on what would happen and whether the state engineer actually had to do anything. And they essentially, when we talked about that in the committee, there isn't language in there sufficient enough to, in my opinion, to protect the junior water rights. And so that's why we ended up striking all of that on page 4 and the bottom half of page 3.
Thank you, Senator. Any other questions on the amendment? Senator Ide, you're on the amendment.
Yeah, thank you, Mr. Chairman. I'll just back up the good senator from Buffalo. Was in on that discussion this morning, and a lot of conversation about trying to protect the junior water right. And even the water guys, they tried to make an amendment. They're just putting no on that last page 4, taking out a couple of no's. And it looked like it was just cleaner to take off that whole section right there and get the junior water rights on a level playing field with the seniors. So thank you, Mr. Chairman.
Thank you, Senator Ide. Any other further discussion on the amendment? Anything else on the amendment? Are you ready for the vote on the amendment? The question is, should Senate Standing Committee Amendment number 1 to Senate File 43 pass? All those in favor signify by saying aye. Aye. Any opposed? The amendment is passed. Back on the bill. Who else wants to address the bill? Anything? Senator Barr.
Thank you, Mr. Chairman. So my inquiry is back to the remaining first page of the bill. A lot of stricken language, and then we come down to this temporary beneficial use, line 2, page 21, and there's an exclusion. That exclusion, I think, is the only change to that component, then I would argue. So what is the rationale for now excluding in-stream flows that I believe the way I read the current statute, they would be included as temporary uses? Thank you, Mr. Chairman.
Senator Craigo.
Thank you, Mr. Chairman. And I should pull up 41.3.1001, but I think it's specifically excluded in that statute as well. So we're just acknowledging there's another statute that deals with that particular carve out for in-stream flows. And maybe one of the other good senators could also chime in and help me on that.
Senator Hicks.
Yeah, Mr. Chairman, this is one of those issues that we really don't need that language in there. When you look at in-stream flow language, only the state of Wyoming can hold an in-stream flow water right. And I'll provide a memo before we get to second reading from the Attorney General, because it doesn't meet the definition of the purpose of a beneficial use under a temporary change of use. In-stream flows are designed as a perpetual water right for the purpose of maintaining an aquatic health of a stream. They're not a temporary use. By their very definition, they can't be a temporary use. And so I think that language was last year was added, but it's superfluous. We do have a memo from the state engineer's office on that, and I'll supply that to the body. Find time we get to second reading, and we can have a discussion then as the relevance of including that in there or not. I think the other part of this is the genesis. This has actually been kind of a 2-year journey that came from Select Water and then went to the Joint Ag Committee this year. Is if you look at all that stricken language and it talks about highway construction or repair, temporary purposes, Department of Transportation. This statute was actually enacted, as my recollection is about 1964 when they were building the interstate highway systems across the state of Wyoming, and they needed water for construction of roads, and there was no real mechanism to do that, and that's why you see this reference of the State Highway Department in there. It doesn't preclude the State Highway Department from going out and getting a temporary change of use. It's archaic. And so part of the purpose with this was to actually come in and clean this statute up and make sure that it reflects what the practice has been historically, and get rid of all that other superfluous language in there for simplification and to bring our temporary change of use statutes up to current provisions and modern utilization within the state of Wyoming.
Senator, any further discussions? Senator Steinmetz.
Thank you, Mr. Chairman. Just to further clarify on the in-stream flow language, that is contained in another part of statute. However, we had a constituency that came to the meetings and felt that that was not clear enough. They wanted it specifically spelled out in this section, and they had grave concerns, and so we did that in response to a constituency. Thank you.
Thank you, Senator. Anybody else? Anything else on the bill? Anything else on the bill? I'm not seeing anything. You ready for the motion? The vote on the question. The question is Senator, who made the original? French's motion that when the committee of the whole rises to report that it do so with a do pass recommendation on Senate File 43. All those in favor signify by saying aye. All those opposed, no. Senate File 43 is passed committee of the whole. We will, the next file for our consideration is Senate File 4. The reading clerk will please read the file.
Senate File 4, State Park Police Officers, Definition and Scope of Authority, an act relating to criminal procedure, sponsored by the Travel Committee, was referred to Committee Number 6, which returned to committee recommendation that it do pass. Ayes, Senators Boner, Hicks, Jones, Lander, and Schuler. Senator Landon, Chairman.
You've heard the reading of the file. What is your pleasure, Senator Landon?
Thank you, Mr. Chairman. I would move that when the committee of the whole rise to report, it do so with a do pass recommendation on Senate File 4, State Park Peace Officers Definition and Scope of Authority. And for an explanation of the bill, I would ask that you call on Senator Jones.
Senator Jones. I'm going back over to the good corner. Senator Jones.
Mr. Chairman, this bill amends the definition of peace officer to clarify and expand the authority of park rangers, superintendents, and assistant superintendents. This bill specifies their jurisdiction and permits them to assist other law enforcement officers upon request. This expands the ability for all peace officers who work as superintendents, assistant superintendents, and park rangers to assist in law enforcement. It specifies that these officers' authority applies only within the boundaries of their respective areas, their parks, historical sites, and such. It also clarifies that they must meet the qualifications as any other law enforcement officer. Currently, the Wyoming State Park Rangers are fully commissioned officers. They do not have authority to assist right now outside of their designated areas. So if an accident happens outside of a state park or something like that, they do not have the authority to go out and help law enforcement or take care of the problem until actual law enforcement can get on the scene. They also cannot enter into any MOUs with any law enforcement agencies in order to help with special events or special areas of the state at certain times of the year. So this would allow them to do that as well. The law enforcement agencies are in favor of this bill. They did speak in the committee meetings, and they are hoping that they are able to get this passed and get the help of our state park officers. And I will stand for any questions.
Thank you, Senator. Any questions for the senator? Any questions? Let's see, let's start over there with Senator Schuler.
Thank you, Mr. Chairman. Again, this was a bill that we worked in the interim, and I think it's a really good fix. What we found out, at least what was reiterated today, is there are only 5 full-time LEAs. They hire 25 part-time seasonals, but they have 42 sites across the state that they have to deal with. And you can only imagine if you were at probably Glendo or Fort Bridger during Labor Day, when you've got, 5, 10, I guess today they said 20,000 sometimes people, and you've only got that few people to deal with those kinds of incidents. They just don't have the manpower. And then the unfortunate part, as the good senator from Rock Springs mentioned, is that sometimes there may be a chase inside the park with a DUI person weaving all over. Maybe they leave the park and these folks can't do anything about it. And they call in someone else, and it may take them 30 minutes to get there. In the meantime, there could be a horrific crash out there on the highway. So this will really help not only our park people, but in conjunction with our highway patrolmen, our sheriffs, and so on and so forth. It'll really bone up them, because obviously we know, if you talk to any of your county sheriffs or your city policemen, you probably know that there are vacancies in just about every area. So this will just give us a little bit more help there. So I think it's a good bill. Appreciate you bringing it.
Thank you, Senator. Was it Senator Ide?
Yeah. Thank you, Mr. Chairman. I'm not a big fan of this bill. I'm glad everybody worked this bill. I think the intentions are good there again, but I think this expands the authority of the state police or state enforcement, against, local law enforcement, county sheriffs that are actually accountable to the voters. So I have issues with that. And, some of the references in there of peace officers, state law enforcement, I disagree with that. So thank you, Mr. Chairman.
Thank you, Senator. Senator Driscoll.
Thank you, Mr. Chairman. I've got a couple questions, and I generally stand kind of opposed to. I'm in favor of expanding the authority within the parks to the additional people. I think that's necessary and good, and I'm really happy. I'm going to ask if they're open to some amendments. I'm happy to have MOUs with local law enforcement, but I'm not very keen on state park rangers working outside of the park, catching speeders and doing stuff just as general law enforcement. I would wonder if maybe the committee or the body would be open to having them be able to go out when they're invited to. If dispatch calls them, says we got a drunk driver heading out, need help, we have a wreck outside of Keyhole State Park, could you guys come help handle this? That type situation, I'm very happy to do it. But these guys all have dual roles, and I'm loath to put them out on the highway acting like a county sheriff or a highway patrolman, which we already have. If they request their help, I'm happy if we can do that via an amendment. Otherwise, I find myself being opposed to the bill, probably.
Thank you very much. Senator Nethercott.
Thank you, Mr. Chairman. I do share some of the concerns that I've heard from my colleagues, and curious as to whether or not the committee considered something similar to the game wardens of our state that actually don't have this broad authority. I know a couple years back, their statutory authority was amended, though, to allow for them, if they saw a crime in real time outside of their jurisdiction or outside of their scope of duties unrelated to what they're typically required to do. For example, if they were to be seeing a robbery in action, our statutes didn't allow them to respond as peace officers. And so we expanded their scope of authority to allow them to respond to crimes happening in their presence so that they could be of service, and also to respond to calls of other agencies. And so I think that limitation is appropriate, making sure that there's not this broad expansion of authorities. So right now, I think, is it fair to say that if I am driving across the state and a park ranger sees me, that they can pull me over for speeding? And are they issuing traffic citations throughout the state, or are they doing drug interdictions across the state because they suspect I'm driving a vehicle from out of state, and there's indications that it could be drug interdiction type of a case, that now all of a sudden our park rangers are going to be engaged in this type of activity. So I do have concerns that perhaps it's a little too broad, and maybe we can narrow it in to address the concerns as identified of being able to respond to calls from neighboring agencies and or to respond to crimes occurring outside of the parks, but within their presence in real time.
Thank you, Senator. Senator Hicks, and then we'll go back to Senator Landon.
Yeah, thank you, Mr. Chairman. And I think that there's some valid points there that have been made. I think that through a very simple second reading, we could narrow some of that scope. But we did take testimony from the organization and then also individual sheriffs in some localities. We have state parks that are very remote. And the situation that we deal with is it may be sometimes up to an hour response time for a sheriff's deputy, and particularly in some of our very large counties with very small sheriff's deputy forces that have state parks. And so it's not uncommon in these larger counties to have a number of sheriffs or deputies on duties, but they're an hour to respond to a state park. And it was really kind of designed to address some of those issues, that if there was let's say something that was a law enforcement issue, drunk and disorderly, activity going on that met the limits of criminal activity, these state park rangers may not have the authority to be able to enforce those laws. And the sheriff's deputy is an hour away, so the intent is to give those people the authority to enforce those state laws, primarily within those. And I think, given the concerns here, we can certainly address that issue and narrow that up and say within the scope or the range of whatever reasonable response time is. But I would encourage us to send this on to second reading, because for those of us that have state parks in very, very remote locations of the state of Wyoming, there may not be any other law enforcement there. And for the protection of public safety, maybe we should just take a look at this and have another discussion, second reading, and hopefully we can work with you to tighten some of your concerns up. Thank you, Mr. Chairman.
Senator Ide?
Thank you, Mr. Chairman. Maybe I can help address some solutions that good senator from Baggs brought up. We brought in a speaker last summer. He was county sheriff. This was up in Casper, up in southern Washington, in a small, big, spread out county, not a big population. And he formed the sheriff's posse. You don't hear those much anymore. And they're all unpaid. And it doesn't cost the federal government, the state government any money. And they kind of are his eyes and ears out on the hinterlands in remote Washington. So just an idea to save the taxpayers some money. Thank you, Mr. Chairman.
Thank you, Senator. We'll go to Senator Crum, and we'll still try to get back there to Senator Landon. Go ahead, Senator Crum.
Mr. Chairman, my one question is, what additional training is required of these folks, the park rangers, to perform duties as a sheriff or a police officer? Would there be additional training, and what would the cost of that be?
Thank you, sir. Senator Schuler is going to take that.
Thank you, Mr. Chairman. Yeah, that's a really good question. And again, it was reiterated again this morning that these people are all post-certified already. So they've had the same exact training that any of the law enforcement folks have. They're not just, wearing a Smokey the Bear shirt with the, gun strapped around them or whatever. And so honestly, they have the same equipment as our sheriffs. They're trained the same way. They've had the same background in everything from their shooting prowess to how to deal with situations. And so it's not going to require any extra training at all. It's just going to require the ability for them to be able to go outside their park area if needed. As was mentioned today by the head man, Mr. Kaufman, that they're not out there looking for, speeders that are just speeding outside the park. They're there to try to deal with a lot of real serious things. And the biggest problem is when there is a serious thing, as I mentioned before, like a DUI, a person is swerving all over the road, who knows that, hey, once I get out of the park, this guy can't do anything about it. And it might be 30, 40, 50 minutes before a sheriff can catch up with me. And those things can be disastrous. And that's all they want, is to be able to help our sheriffs, help our highway patrol, help our other law enforcement people. They are trained just like them. And so I just wanted to make that perfectly clear. Thank you.
Thank you very much. Have we covered it? Senator Hicks?
I'll address my colleague from Natrona County's question about the cost. If you turn to the last page of the bill, there is no significant fiscal impact associated with it. And in concept, it does exactly what my colleague says, is to kind of create a posse. And so what we're doing is we're using, as the past chairman said, these people have the exact same credentials as your sheriff's department. In fact, they could just take a job tomorrow and move over, and it doesn't require any more time at the academy. So they have the exact same credentials. So in effect, what it does do is it creates I would say, the posse concept, because they're already paid for, they're already trained, but they can't enforce certain state laws within state parks or adjacent to state parks. And so this does create a little more opportunity at no additional cost to the taxpayers to provide that public safety. And so, but I think it really kind of meets the thing is how do we expand the services for public safety without increasing any cost? So anyway, thank you, Mr. Chairman.
Thank you, Senator. Let's go to Senator Jones. Maybe she'll bring us home.
Thank you, Mr. Chairman. Just to reiterate, right now, full-time, we have 1 chief ranger and 4 other full-time rangers across the state. And I mean, that really keeps them busy doing their full-time jobs. This is just limited law enforcement help, and there will be a new state park internal policy that will only allow them for limited law enforcement actions outside of their properties. So they're not just going to be cruising around looking for stuff outside their jurisdiction. This is just for in their designated areas.
Thank you, Senator. Are you ready for the question? The question is on Senator Landon's motion, that when the Committee of the Whole rises to report it, do so with a do-pass recommendation on Senate File 4. All those in favor signify by saying aye.
Aye.
Any opposed? No. Senate File 4 is passed Committee of the Whole. Senator Garreau. I probably ought to turn you on if I'm going to call on you.
Thank you, Mr. Chairman.
You're welcome.
Privilege of the floor.
Yes, sir.
Thank you. Ladies and gentlemen of the 68th, Mr. Chairman. So I want to introduce a friend of mine who's down visiting from up in our country, up in Teton County. Has a very important job. He is the owner of a little outfit called Something in Our County and Something About Media. And so also does something with our local paper of some renown. His name, I can say, is Kevin Olson. He's sitting right here. So please give him
welcome.
welcome. And Mr. Chairman, also, I wanted to say that this outfit that he works for, a bigger outfit around the state that has the same work, they're having a party tonight. And it's at a hotel just down south there it's a big hotel that has a little name. And so it's down there, and it starts about 7:30, it goes on from there, and they'd love to see. So
Thank you very much for that. Senator Barlow.
Thank you, Mr. Chairman. Privilege of the floor.
Absolutely.
Thank you, Mr. Chairman. So if members, my colleagues in the Senate, if you'll please join me in welcoming Wyoming's 21 credit unions, member-owned financial corporations serving 330,000 members across Wyoming, 69 Wyoming branches, 900 employees, and $178 million into Wyoming's economy. If they'll stand up, they are representing
over
Trona
here
Bank,
too.
Atlantic City, Sunlight, Pathfinder, Uniwyo, Stage Point, Blue, First Education, Meridian Trust, YSI, and Black Hills Federal Credit Union. Please welcome them to the Senate.
Here, here. Thank you all for coming down today. Thank you very much. Madam Majority Floor Leader, that clears the desk. I got to get you a microphone. There you go.
Mr. Chairman, I move that the Committee of the Whole rise and report.
You've heard the motion. What is your pleasure? All those in favor signify by saying aye.
Aye.
Any opposed? Mr. Vice President.
Thank you.
Welcome back.
Where are we? Thank you. The reading clerk will read the Committee of the Whole report.
Mr. Vice President, your Committee of the Whole, having had under consideration bills on general file, begs leave to report as follows. Senate File 23, do pass. Senate File 50, do pass. Senate File 67, laid back on general file without prejudice. Senate File 32, do pass. Senate File 43, do pass amended. Senate File 4, do pass. Senator Case, Chairman.
Thank you. Senator Case. Excuse me.
Mr. Vice President, I move for adoption of the Committee of the Whole report.
You've heard the motion. All those in favor say aye.
Aye.
Those opposed? Carried. We have announcements. The Committee of the Whole report has been adopted. Now I apologize, now we have standing committee reports.
January 16, 2025. Mr. Vice Presidential Committee Number 1, Judiciary, to whom was referred Senate File 11, use of fraudulent documents to wrongfully possess property. Respectfully report same back to the Senate with the recommendation that it do pass. Ayes, Senators Cragel, Crum, Hicks, Kolb, and Olson. Senator Olson, Chairman.
And I think that clears the desks.
Time for Majority Floor Leader.
Senate Majority Floor Leader, please.
Mr. Vice President, I move that we stand adjourned until 10 a.m., January 17th, 2025.
Announcements? Senator Barlow.
Mr. Vice President, your Committee Number 10 will not be meeting tomorrow. We will have a meeting on Monday to consider one bill that will be noticed by tomorrow. Thank you.
Senator Case.
Thank you very much, Mr. Vice President. Your Committee Number 7, Corporations, will meet tomorrow morning at 8 a.m. in Capitol Extension Room W4, and we will take up the following bills. Senate File 53, Trademarks and Trade Names Administrative Cancellation. Senate File 55, Third-Party Filers. Senate File 56, Providing False Information to Registered Agents. And Senate File 59, Registered Agents Release of Records. Thank you very much, Mr. Vice President.
Thank you. Senator Schuler.
Thank you, Mr. Vice President. Senate Education Committee Number 4 will be meeting tomorrow, 8 o'clock, room W110, and online to take a look at Senate File 34, School Finance Routine and Major Maintenance Calculations, Senate File 44, Fairness in Sports and Collegiate Athletics, Senate File 72, Summer Vacation Preservation Act. And just to give you a heads up, Education Committee We will also meet Monday morning to take a look at Senate File 90, Youth Organizations in Schools, Senate File 21, Ban on Cell Phone Use, Senate File 73, Charter School Funding Amendments. Lots of work to do.
Thank you, Senator. Senator Driscoll.
Mr. Vice President, welcome to the chair. Your committee, number 2 Appropriations, will meet tomorrow, Friday, January 17th at 8 a.m. in the State Capitol Room E301 and online. Thank you.
Thank you. Senator McEwen.
Yes, Mr. Chairman. The number 3 committee revenue will meet tomorrow upon noon recess. We will be taking up Senate File 49, followed by Senate File 48 in W06.
Senator Anderson. Senator McEwen, you want another shot?
Yes, Mr. Chairman. Can I get back to you?
Okay, sounds good. Senator Anderson.
Mr. Vice President, Minerals Committee will have a revised address. We'll still meet Friday, January 17th upon noon recess in Capitol Extension Room W4 and online, but we'll only hear 3 bills. Senate File 17, Carbon Dioxide Enhanced Oil Recovery Stimulus. Senate File 18, Enhanced Oil Recovery Severance Tax Exemption. Senate File 19, Impact Assistance Payments, Maximum Percentages and Review. Thank you.
Senator McEwen.
We'll give this another shot. Number 3, revenue will be meeting tomorrow upon noon recess in W06 to take up Bill 49, Tangible Personal Property, and Senate Bill 48, Business Property Exemptions.
Thank you. Any other announcements? Senator Rothfuss.
Thank you, Mr. Vice President. Mr. Vice President, your committee number 12, Senate Rules, will be meeting 15 minutes after adjournment, so about 3:45 today, Thursday, January 16th, to discuss Senate Rules. My apologies, in Senate West 113, West 113.
Thank you. Senate Majority Leader.
Thank you, Mr. Vice President. Just a reminder, senators and members of the public that might be interested here in the Capitol, the Supreme Court is hosting an oral argument in our historic Supreme Court here in the Capitol at 4 p.m., so in about 30 minutes. It is a case that I think is uniquely suited to our interest. It is Teton County versus the state of Wyoming concerning whether or not declaratory judgment should have been granted that declared that the state of Wyoming Board of Land Commissioners and their permittees are not subject to the county's land use or development regulations on state trust land, and other issues concerning local regulatory authorities versus state authorities. So right up our alley that we love to have. It will be here in this building in 30 minutes. Those parties will be making an oral argument to our Wyoming Supreme Court on this historic day. Thank you so much.
Any other announcements? You've heard the motion. All those in favor say aye. Those opposed? Carried. We stand adjourned until 10 a.m. Friday, January 17th. Thank you.